Hello and welcome to today's webinar on what are my clients' legal rights after a disaster. I'd like to start by acknowledging the First Nations custodians of the land where legal aid officers stand and where we work to help disadvantaged Queenslanders uphold their legal rights in our justice system. We pay respect to their elders, law, customs and creation spirits, and we recognise that these lands have always been places of ceremony, teaching, research and learning, and we acknowledge the important role Aboriginal and Torres Strait Islander peoples play in our community and in improving our legal system. So welcome to today's webinar. As I mentioned, the topic today is what are my clients' legal rights after a disaster? Unfortunately, as your facilitator, I'm off screen. My name is Catherine Gorder. I'm the Community Legal Education and Engagement Coordinator here at Legal Aid, but I'm very happy to be here today with our presenters who are sitting next to me, Paul Holmes, our Director of Disaster Relief, and Julie Marant, who's a lawyer in our Civil Justice Services team. Thank you very much for both being here and welcome.
Thank you, Catherine.
Before we kick off with today's content, there's just a few pieces of housekeeping that I need to run through. So just a reminder that today's webinar is being recorded and the law and content are accurate as of today's presentation date. It is not meant to be legal advice, it is legal information only. If you do have any audio or video issues with your webinar today, please contact GoToWebinar customer support for technical help. Unfortunately, we at Legal Aid can't give you that help during a live webinar. So the format of today's 1 hour webinar is about 40 minutes of presentation time and we'll have about 20 minutes for a Q&A section. We can take your questions throughout the webinar and I know Paul and Julie will be talking through some case studies. So if you have a question that you want to ask that's relevant to what they're discussing, please pop it in the question box. I'll be keeping an eye on that and I'll throw it over to the presenters to discuss. We do have a copy of today's PowerPoint slides available to download as a handout in the handout section on your screen, so please grab that. And I'll jump into our very first poll. So this is an opportunity for you to tell us a little bit more about you. So our first poll is what region do you work in? I'm just launching that for you now. So the answer options are South East Queensland, Far North Queensland, Regional Queensland or outside of Queensland. I'll give you about 10 seconds to pop your answers in there and then we'll share the results. So far it's looking like more than half of our audience are from South East Queensland. A couple more seconds there. Okay, I'll close that off and share the results with you all. So 53% are from South East Queensland. We do have 17% from the far north, 15% from regional and 15% from outside of Queensland. So Paul and Julie, is there anything we need to note about what's being discussed today? Is that still relevant to people joining us from outside of Queensland?
Most of that law is indeed Commonwealth law, but if there's state-specific law, we'll mention that.
Okay, perfect. All right, I'll jump into our next poll. So this is asking, what is your role? I'll just launch that for you. So the answer options are support worker, financial counsellor or health education worker, social worker, lawyer or other. So just pop your answers in there. I'll give you about another 7 seconds. Looks like about half are financial counsellors or health education workers at this point in time. Couple more seconds. Okay, I'll close that one and share the results. So 44% financial counsellors or health education workers, 21% lawyers today, a few social workers, a few support workers, and 30% are other. Thanks everyone for that. We've got a couple more polls. We'll get through them as quickly as we can. So the next one is just helping Paul and Julie understanding your role and your experience in working with people impacted by disasters. So I'll just launch that one. So this is asking, what's your experience with people recently impacted by disaster? So whether you're currently helping, have previously helped, if you've got some knowledge but haven't actively helped someone, or you've been personally impacted, or you've had no experience. I'll just give you another 5 to 6 seconds to share your response. Couple more seconds. Okay, close and share results. So about a third are currently helping people being impacted. About another third have previously helped, and the rest is made up of people who have some knowledge or limited knowledge. So thank you, that's very helpful. And one more, I'm sorry, I hope you don't all have poll fatigue. Last question, which I'll share with you. How much experience do you have helping people experiencing legal issues following disaster? So none, have helped some, have helped many. This is now or has been my role. Just a few more seconds. Okay, I'll close that off and share. So about half of our attendees have had no experience with this. Almost a third have helped some people in the past. So thank you. That's just really helpful for us to understand who's joining us today and your level of knowledge. That's it for polls. So just to quickly run through what you're going to learn today, what we'll be covering. So we'll be looking at what are some of the common legal issues people have after a disaster, what rights do consumers have when faced with these legal issues, and how can lawyers assist clients with these issues. And now it's time for me to hand over to Paul and Julie. Thank you, guys.
Thank you, Catherine.
Thanks, Catherine.
Welcome, Julie. Just before we start, just wanted to acknowledge the difficult time people in North Queensland are having at the moment, particularly Ingham and Cardwell, Halifax, Townsville, as far down as Ayr. Some of those rainfall figures are just really hard to comprehend. I saw some today suggesting places that had 2.7 metres of rain in the last 14 days. So our thoughts are with you, and we will be there supporting you right through this. All right, our focus for today is on some practical case studies. These are what we've tried to do is create case studies that reflect the pain points that clients experience and are often seeking advice from us about. And so the discussion will go beyond insurance, and we'll look at things, insurance, financial hardship,
Domestic
violence, potentially fines, or a whole range of legal issues that people are experiencing following a disaster. So you can tell I was a child of the 80s because the first case study involves George Jetson. Those of you who don't know who that is, send me an email afterwards and I will explain that. So just give you a few seconds to have a bit of a read of the information before we start talking it through. All right, Julie, when George comes to see you, what's your first thought?
So we're at a recovery centre, which is something that's set up straight after a disaster. So very first thing, it's really important that whatever I do is trauma-informed practice. And George, Jane, Elroy, Judy, the kids, the dog, have been through a harrowing life experience, and his ability to absorb information from me is limited, and his ability to recount in a chronological order is limited. So that's my first thought. Secondly, it can be noisy in a recovery centre, and it can be difficult for him to provide information. We've got to keep all of that in mind.
And you and I have both had instances where at a first meeting all we've been able to do is have a cup of tea.
That's right. That's right. And we have been the first person that somebody says out loud, oh, Auntie Linda's bowl got washed away. It can be quite an emotional experience for the client while they're speaking to us. And it's important to keep in mind for all the people on the call who are consumer helpers, that it can be really harrowing for you as well to have that one after another, after another, after another. So you've got to make sure that you look after yourself as well when you're providing assistance in these circumstances. But back to George's legal issues.
Where do we start?
So we start with, what's most important to George.
Yep.
And what's most important to him seems to be jumping out at me that his wife and kids have gone to Brisbane and he's sleeping in a tent. So
Yep.
housing first. And that's about whether he is entitled to temporary accommodation under his policy and why that hasn't been paid immediately. So sometimes we see clients who think that if they get temporary accommodation, that amount comes off their sum insured and they won't be able to build a 4-bedroom house, it'll be down to 3 bedrooms.
Yes.
So that's not the case, and being able to provide that information to George straight away means that he can take steps to get his family back together as one unit and get into temporary accommodation while the works are going on. If that claim to the insurance company is knocked back, we can provide immediate assistance with internal dispute resolution and external dispute resolution to get that happening.
Now, there's a couple of clauses we deal with when it comes to temporary accommodation. In some policies, there's a fixed amount of money you get for temporary accommodation, and in other policies you get, say, 12 months worth of temporary accommodation. So probably it's worth exploring which clause he has to see how best to help him, because particularly following a disaster, accommodation can become very expensive very quickly.
Yeah.
And you can eat into fixed sum amounts very, very quickly.
That's right, or percentage amounts or duration. There's always going to be an end to the money. And if you're in an Airbnb at a nightly rate for 12 months, or for George, he's been three months so far, that can be a problem as well.
One of the things though we often say is I experience people who are desperate to stay on their property. Absolutely desperate.
Yeah.
And in that situation, I am aware there's some insurers out there that will consider allowing people to use that temporary accommodation money to, say, buy a caravan to live in.
Yeah, that is something that we saw in New South Wales after the Duns Road fire in 2019-2020, and until the local dealers ran out of vans.
Yeah.
But that was the preference of the local country folk in New South Wales, that they wanted to be close to their properties, they wanted to keep their pets with them,
yeah.
and they have connections, and so that was something that the insurers agreed to. But at the time there was a question about whether local council would allow people to live in their caravans on their properties. And that is something that we were able to assist people to resolve directly with local council. That's always going to be a local government issue, and each council will have their own regulations.
And if there's anybody from local councils up north on the line, can you start thinking about that issue for us? Because it's going to be an issue in North Queensland, because the other issue with temporary accommodation is we're in a housing crisis.
We already had limited housing, and now a lot of the housing stock is submerged or unlivable, and so it busts up communities, it busts up families when you can't provide local, long-term, affordable temporary accommodation for people.
And it's not unusual following a disaster, following a hailstorm in Queensland about 4 years ago, the enrolment in the local primary school dropped by a third following the disaster.
Such a lasting impact on the community. But we can move on to his other actual legal issues. So once we've got his housing first and his family back together, that's a good first start for George. But there are some specific issues with his insurance claim and what he might be covered for.
Let's start with my personal hobby horse with maintenance.
Right, is that so his roof maintenance.
So it's not unusual for people to get a response from an insurer saying, we're going to pay part of your claim, but we're not going to pay all of it because of pre-existing damage or a lack of maintenance. My first step there is always to get a hold of the reports, because for an insurer to have made that decision, there's a report they relied on. It would be fair to say in the time we've been doing this, those reports can be wildly inconsistent in their quality. Would that be a fair comment?
I think that is a fair comment, and that's not necessarily critical of the reports, but they do vary greatly, and it always is worthwhile delving into the detail of the reports.
Because what we're after is, if an insurer is going to deny a claim partially, they've got the onus to show that they can rely on that exclusion. So if I'm looking at these reports, I'm looking for the report to say, okay, the maintenance you haven't done is 1, 2, 3. The difference it would have made to the roof is this. And if it had been done, the damage that occurred in either the flood or the disaster either wouldn't have occurred or would have been substantially less.
Yeah, agree. And we have very helpfully there put some of the acronyms that we are bound to be just chucking out at each other right now.
Absolutely.
So when we say IDR, we mean internal dispute resolution, which is a process that we do directly with the insurance company who's made the decision about his claim. If that is not a successful process for our client, then we can escalate to an external dispute resolution process.
Absolutely. And I guess the other thing to say about maintenance is my experience is clients have no idea what they're required to do to maintain a house.
No.
Not a clue at all.
I don't at all.
And so I think there's some work to be done by us and insurers and other organisations around getting messages out about what maintaining a house actually looks like.
I think you're absolutely right, having just bought a house with the pre-inspection report, suggesting that we do a couple of things. But I have seen when we talk about looking at all of the reports, I have seen a client whose pre-inspection report from when they bought the home several years earlier was used as part of the evidence by the insurance company to partially decline their claim. And in that case, I think we ended up having a look at 4 or 5 reports and looking at the detail and the consistencies and inconsistencies between them. And so it can get a little bit complex, but you've boiled it down to the really simple principle of it's up to the insurer to show what wasn't done and what actual difference that would have made to the result.
Absolutely. And that probably leads us nicely onto the cash settlement discussion.
My new favourite.
This is another one that consumers really struggle with.
Yeah. So so George has been offered $50,000 cash settlement with 5 days to accept. Like, that's a thing. But in his view, it will cost $200,000 to repair his home. What's $50,000 supposed to cover? And that's an excellent question from our client, George. So cash settlement offers, there's been some regulation about when they can be made and how they need to be made and what information the insurance company should be providing to their customer in making that offer.
Yeah, and the sorts of things it's reasonable to expect is a copy of a scope of works. Now, a scope of works is a very detailed line by line listing of everything that needs to be done, right down to how many screws you need to put in the roof in order to get the property fixed under what's covered under the insurance policy.
Yeah.
The thing about that is it should also include the amounts of money this would take if we're talking about a cash settlement, because it's really difficult for a consumer to work out whether the cash settlement offer is reasonable if there aren't figures to go with it.
Absolutely.
And you'll often see clients go and ask a second builder to do them a quote as well, because it's not unusual for the quotes to differ as to how much money it will actually take to fix something.
Yep. But you're right, it's incredibly difficult for the consumer to challenge what's in a scope of works that's not itemised with dollar amounts, even with their own builder's report, because it's not clear how much is allocated to each screw and each widget. And so it's really reasonable in my experience to ask for those scopes of works to be itemised with the actual amounts.
Having said that, if the insurer is doing the work, I'm okay with the scope of works not having the money.
This is only for cash settlement offers. So maybe we need to just go back a little bit and talk about what the options are. And this is part of the information that should be in a cash settlement offer, what the other options are. So the consumer will usually have the option for the insurer to engage the repairers and do the works, or take a cash settlement where the insurer pays to the consumer the amount of money that it would cost the consumer to do the repairs themselves. And so some of the things that George would need to think about, other than that it's woefully inadequate, are what we've put on this slide. Does he have to accept? Does that mean that he'll have to be the project manager for his repairs?
Yes, he does.
That's right. And then what happens to the payout when he's got a mortgage?
Yeah, and the answer is, and not many people know this, is that we all have clauses in our mortgages that say that money can be paid directly to the bank who holds your mortgage. Now, in my experience, they very rarely hold on to it. they're more interested in making sure the property's fixed and the value of their security gets back up to scratch. But it's really important people have that conversation with their bank or their finance provider before accepting a cash settlement.
I agree. And I have seen one case where the insurer was insisting on sending the payout directly to the mortgagee. I always get those two mixed up. Who was listed on the title. So
it happens.
It is something important.
And then they have to submit invoices to their bank about the repairs.
Oh my goodness. And he's already been through enough. Poor old George. So back to the main question here though, does he have to accept their offer of a cash settlement?
Absolutely not. And that's where we go into talking about internal dispute resolution and external dispute resolution. But for that to be successful or have the best chance of being successful, another quote or another two quotes are often a good thing. Because my experience is it's no good saying to external dispute resolution or internal, you're wrong.
Yeah, that's not very compelling, but you're wrong and here's the proof of how you're wrong can be really compelling.
Exactly.
In my experience, sorry, Paul, after a disaster, some people want to leave.
Absolutely.
This bushfire is the 7th bushfire that they've lived through. They've had enough. They want to leave. They don't want the house to be fixed. They want the cash settlement. What can they insist on it?
Townsville people, I'm thinking of you here. Yes, you've had a few in recent times. So you don't have to get it fixed. Absolutely not. And I've seen people go, we need to get out of here. But again, that's a discussion you should have with your bank before you do it.
For George with a mortgage, do insurance companies often insist on doing repairs rather than payouts?
Don't. Insurers are generally very good if somebody says, I can't do this anymore. They're not going to insist on something being fixed.
Excellent.
But one of the things we've missed, as we've been discussing, the roof was inspected 3 weeks before the damage, Julie.
You missed that, Catherine. You could go back to that slide if you wanted to, just to show everyone what we missed. But the roof was inspected 3 weeks before the cyclone. And in my recent experience being a Queenslander, but not for footy, this is something that people in Cairns, people in Far North Queensland who are
actually
living
pretty good at doing
in areas that have the monsoon and have cyclones, they do this.
Yep.
As if he would get, no, they do this. And so that roof inspection that he had done 3 weeks before the cyclone,
showed no problems.
That is a report that George could very easily and successfully put in internal dispute resolution to the insurer to knock that on the head.
And if we do have insurers online, if somebody has 3 pages worth of reports they've done showing how they've maintained the property, can you please not refuse it?
If we've got insurers on the line, I don't think they'd be the type that would refuse that.
Exactly right.
It'd be the ones not watching. We need to chase up with that.
I'll just jump in here. A question has come through from an insurer, and I'll comment on the question.
So
he has said, I completely understand and agree that we need good, clear reports if we are partially declining a claim for maintenance. One of the things we battle with as insurers is where we have an acknowledgement that the customer needs to complete some form of maintenance before we can complete the insurance repairs, but this drags on indefinitely while meantime the damage may be getting worse.
And look, I think that's a really good point. Where I think insurers can be really helpful in this space is at the moment, most of that information going to the customer just says, you need to fix this. What I'd love to see insurers do is saying, okay, for us to do our work, you need to fix this. The sorts of experts you need to speak to about getting it fixed are an engineer, a roofer, and here's a couple of local people on our panel who may be able to help.
And after you do that, then this will happen. Because this goes back to the ability of people who have been through a massive disaster, sometimes involving a near-death experience, and choosing which wall of flame is the shorter one to drive the tractor through, that it can be difficult for them to take in information and to interpret it in a way that they otherwise would usually. And I think it would be really good practice by the insurers to refer people to Legal Aid Queensland for help if it involves that sort of complex information that's being provided, and then we can both be on the same side of helping the consumer after a disaster.
Yeah, I agree. So it's a really good question, and it's a problem we wrestle with as well. But that sort of extra information would help both the consumer and us to get that person back on track. So no, thank you. Excellent question. We
didn't talk about his car yet.
No, we need to talk about the car. And
are we onto the car?
We are onto the car.
Okay.
So this is straight out of casework. Often.
This happened to me too.
Yep.
Oh my gosh. Yep.
Often following a disaster, there are cars in mechanics yards. Often those mechanics yards are on the low-lying areas.
Yeah. Sorry, for floods, the low-lying areas, the cars are inundated and end up with more damage than they were driven or towed in with.
Exactly. And then there's a question round, yes, your insurance will cover it usually, but should the mechanics insurance cover it? And
who decides that? If I have my car at the mechanics yard, this isn't, I actually don't know, can't remember. And it's damaged by flood while it's at their yard.
They have some responsibility for that.
And so do I need to go to the mechanics claim or the mechanics insurer, or does my insurance company do that on my behalf as if we were in a car accident?
The reality is, in my experience, those mechanics yards very rarely have flood insurance.
Oh.
Is the reality.
Yeah.
So you're looking at things like bailment.
Yeah.
Which is where you would have to go to QCAT, which is our local tribunal, and argue they had taken on a duty of care by having that car in their yard. And then the court would make a decision about whether they met that or not. But failing that, you may be reduced to claiming on your own insurance. And if you do that, generally speaking, the insurers will see whether or not they can recover any money from the people they feel are responsible for the damage.
Yeah, but if you don't have insurance or your insurer knocks it back, well, if your insurer knocks it back, come talk to us. We'll IDR and EDR the heck out of it. But if you don't have insurance, then it's QCAT. And what we were considering for George's situation was not having that car back in the time frame that he had expected to have it back. Meant that he didn't have transport to get to work, which meant that he was fired from his job. So poor old George, it just gets worse and worse. So what can he do?
That's where you need to talk to our employment lawyers and get some employment law advice about your rights.
We're just consumer lawyers. But the important thing to remember there is that the time frames for an unfair dismissal, this is federal law, very, very short, within 21 days, and hardly ever an extension of time. So if that is something that's happened that you come across at a recovery centre, you need to escalate that to legal advice as quickly as you possibly can.
Absolutely, and it's just highlighting that disasters aren't just insurance issues.
That's right.
There's a whole range of legal issues, and the final one we haven't talked about on this case study, and just looking at the time, we're no chance of getting through all 3 case studies, guys, so we'll tell you now. But the good bit about the slides is they have, following the case study slides, showing what the issues are. So if we don't get to case study 3 and you've got questions about it, just shoot us an email and we're happy to respond.
It's our favourite thing to do.
But the final thing we haven't talked about is the mortgage. If I haven't had work for 3 months, I'm probably behind on that.
Right. So as consumer lawyers, we definitely know the answers to this. So this is where you would apply to the bank for a hardship variation, meaning they vary the contract, the terms of the contract of your loan to either put the repayments on pause or a reduced amount, or to somehow make it so that you're not in financial hardship because of the mortgage. It needs to be a sudden unexpected event that caused it, and that you will get back on your feet once this is over. Sometimes in our experience, banks are often very quick to promote their support for the communities and to actually provide meaningful support to communities affected by disaster. But sometimes, unfortunately, that can be short-lived, and 8 weeks isn't always long enough amount of time. There is no specific amount of time that a short-term hardship variation should run for. It's just that it shouldn't be forever, and it will depend on the circumstances for the client.
And it's not unusual for people to take 2 or 3 years to recover from a serious disaster.
That's right. So we're still seeing people from the 2022 in South East Queensland.
And at the end of last year, I assisted somebody with a 2019 Townsville flood case.
We should probably check in on them.
We have been. They're doing well, and the insurer is doing a good job with them now, which is great to hear. All right, it's probably a good time to move to case study number 2, I reckon. And then my 80s upbringing striking again with the Adams family. All right, so where we're at with this one. We talked a little bit about this, but this is one of those problems that, to be fair, insurers are reasonably experiencing at the moment, which is there's a lot of homes damaged right around the country. There has been in the past a shortage of trades and shortage of access to materials to fix stuff.
That is fair to say. And when we started in this area of consumer protection, helping people with disasters, it was more common for there to be one event at a time.
Yep.
And not the rolling constant catastrophes and significant events that we're seeing now in more than one location, sometimes of different types. So I think 2019-20 for me was the turning point in the bushfires and floods all up the New South Wales coast. And I know in Queensland there was very similar up here. So this is not unusual for us to not see a client until quite a while after the disaster, rather than at a recovery centre straight after. And for Wednesday's case, have we given people time to read through it? Sorry.
We've been chatting away. That's very well we're chatting.
Read it at your leisure. So when she first comes in to see us, it's not unusual for our clients to have a limited understanding or grasp on what's actually happened and what the correspondence from the insurance company means. And from what I'm seeing with the recent clients that I've got now in Queensland, that the delays and the shortage of trades and the shortage of materials and the dispersal of the work across the whole state means that the timeframes are really blown out compared to what they were 10 and 15 years ago.
And there's almost an argument to say we need to relook at temporary accommodation clauses being for 12 months. Because the reality is, in some of the more complex cases, it's taken longer than that to fix things.
Yeah, we never used to have to look at whose fault it was that the temporary accommodation ran out.
Yeah.
Because that was an unusual circumstance and the house was rebuilt or the cash settlement was made.
Whereas it's more and more common.
That's right.
And to be fair, a number of insurers that I've spoken to are looking at extending on a case-by-case basis those 12 months. So if you encounter a client in that position, it's definitely worth helping them having a chat to the insurer about potentially what assistance can be provided. No promises, because I'm not an insurer, but I have had some good experiences.
That's right.
Helping clients in that space.
We have seen, not in my own cases, but I've seen some determinations at AFCA where the delays in getting the work done has meant that then it's fair and reasonable in those circumstances for the insurer to pay more for the temporary accommodation. So what we've got for Wednesday is that she comes to see us in the office for one appointment, and then she comes back for a second appointment. So she tells us a bit about what she understands the situation to be at the second one, and then some more information comes out at her second appointment, which is not unusual, particularly for a victim survivor of domestic violence. So she tells us that her property is jointly owned with her husband, but he's not living there because he's not allowed to. But her husband is also on the insurance policy. And so she feels it's difficult for her to make any decisions about what happens next because her husband says no.
And the reality of a joint insurance policy is there needs to be agreement usually as to what happens with some funds. So for me, the first step here is actually ensuring safety. Because one of the things that often happens in a disaster is it exacerbates existing issues and existing tension. So our first step here is to make sure that Wednesday is safe before we deal with anything on the insurer.
Absolutely. It is sadly, like NRL Grand Final weekend for domestic violence survivors, where there is something big, where there is an opportunity to exercise coercive control. We'll just move on to the next slide, Catherine, where we have some information about how we would approach Wednesday's situation. And much like George, somebody who's come to us soon after a disaster, with Wednesday as a victim survivor of domestic violence, is very important again for us to be trauma informed and to approach her as a whole situation. And I guess the only thing I'd throw out there now is that Legal Aid Queensland does have our domestic violence support unit. We are consumer lawyers who are trained in trauma informed, but we don't have the totality of what.
Which is what's good about Legal Aid. We've got pretty much a one-stop shop here.
We've got it all covered.
Which is good.
So Wednesday doesn't understand the scope of works or what they've approved or what's going on or what's being rebuilt.
So step one is we sit down and have a look. And one of the things I often do with that is talk to the client about how many rooms are in the house.
Yep.
And you go through room by room. Okay, living room, did it have any damage? What do you reckon needs to be fixed in there? Do we have that on the scope of works?
Yep.
Bedroom, what happened in there? And your steps, because you're breaking, like you said before, you're then breaking down the information into more bite-sized chunks that people can more easily deal with.
Yeah.
And what I often tend to find is there is often stuff left out.
Usually, always.
And sometimes it's an entire room.
Yes.
Insurers don't mean to do that, but sometimes it is.
Yeah, and clients don't mean to do that, but straight after it, it is not unusual for clients to forget how many rooms are in the home, to forget about a laundry,
Yep.
Always ask about the back sheds.
Yep.
That might just be my country roots coming through, but
No.
Always ask about the back sheds and what they had in them. But I think there's a real difference between a consumer advocate or a consumer lawyer stepping that through with a client to an insurance company asking for an itemised list of everything that was damaged and that you lost, which I think we come to in the next case study. But this is a trauma-informed, chunky, bite-sized, what did you lose?
And I guess the other thing to talk about in that space is often by this stage, rightly or wrongly, the communication between the insurer and the client's broken.
Yep.
If it's been going this long, there's a connection that's either no longer there or always never there.
Yeah. So what it looks like though in Wednesday's situation is that it's been possibly just a lack of communication because it's overwhelming for her, and not that it's been adversarial or what's that, the opposite of amicable, but you know what I mean, that it's not that the client's been fighting with the insurer, the client has been trying to deal with her life.
Yeah, and that's a good call out. It never hurts to remind people on the other side when you're dealing with them. Sometimes you've got to say, look, they're just not going to get to that by the date you've said.
Yeah.
It's just not possible.
And
when you do that, mostly they're pretty receptive.
They are. And especially in situations such as Wednesday's, where not only are they just usually good, decent people who work for insurance companies, but they have obligations in the general insurance code of practice. Did you want to talk about what we've seen with their policies?
I guess the best call out I can make here is there's a number of insurers, and I think the others are working towards this as well, who've essentially introduced a clause in their policy that allows them, and it's not specifically reflected in this case study, but often what you see is in this case, the husband might have deliberately damaged the property or burnt it down in the DV situation. And technically speaking, under insurance law, as they're on the insurance policy, they have caused the damage and the insurer can't pay out. What insurers have done, and I'm a big fan of this, is there's now a clause in their policy that effectively says we have the discretion to still pay the party that was not at fault. And I think that's an excellent addition.
I think that's brilliant, and it's definitely a good, a much needed improvement. What I'm interested in for Wednesday is how will the insurer approach this? I don't know the answer to this, and I'm hoping that I don't need to find out with that specific case study, but I'm interested in how we would use the insurer's obligations in the code of practice, and as evidence of good industry practice when we take it to EDR to what would we do here? And what would be fair to resolve here? The perpetrator.
One of the first things I'm doing is getting Wednesday family law advice.
Tick.
Because the husband here, in my experience, is going to continue to say no. And so they're very definitely at odds with each other as to how to deal with it. That potentially puts safety at risk as well. So you want family lawyers involved, and you probably want some sort of property settlement discussions to start happening about how that's going to be resolved. The insurers, in a sense, are stuck here until they get one decision, because they can't pay up to one to the exclusion of the other, leaving aside that clause we've already talked about. Because the husband has a right here, because they own the property, to have some say in how the money's dispersed.
And then once there's a property settlement, then we know what will happen with the property.
One thing I do know has happened in the past is a trust account got set up, and the money from the claim got paid into the trust account until the family law process could be resolved.
Excellent. I did not know that. But in the circumstances where that then delays the claim even further, either repairs or a cash settlement, but also it looks like there's been a delay with the work not starting until 4 months after the claim was approved, and then there's a trades shortage. What would we look at with temporary accommodation, and whether we could make a reasonable argument that the insurer should cover more of it?
Well, before we get to that, I would want a discussion to be had about, okay, it doesn't look like we're going to be able to start repairs, but can we get a make safe done so that the damage doesn't get worse?
Excellent.
Would be my first step.
Remember that. Yeah.
Because it's in both parties' interests to ensure the damage doesn't get worse and the property is safe, so it doesn't deteriorate further. Would be my first thought. The second thought about the temporary accommodation goes back to the discussion I think that we had earlier.
Yeah,
with George around, mostly insurers are receptive to that idea where it can be shown it should happen a bit quicker.
Yeah, and I have seen AFCA determinations where they're also open to the idea that if there's a delay that is caused by the insurer and it requires the temporary accommodation to go for longer, that is reasonable that they should pay for that. So
exactly. Catherine, do we have any questions that have been popping through?
We do, actually. Let's jump in.
I thought there might have been.
There's one about this case study. So thinking about Wednesday Adams, so personal property damaged and then removed by a subcontractor working for emergency housing caravans. So the residence gate was damaged during a water delivery.
Yep.
Another one's just come through. Let me just find it again. The gate then observed as being totally removed without owner's knowledge. What are Wednesday's legal rights for financial compensation for restoration of removed property gate?
That would be a claim for property damage against whoever damaged it. And depending on the insurance policy, it may also be covered under their insured.
Okay. Yep.
What else has been coming through?
Okay, same case study. So for Wednesday.
Yep.
Same resident has received bullying, harassing behaviour by subcontractor. Resident so fearful if she complains her emergency caravan will be removed due to the incident where subcontractor alleged she hit him. Camera footage clearly shows no contact made. XCV female feeling extremely vulnerable, subcontractor chest bumped her out of the way.
This is sounding suspiciously like a real life case to me. I reckon the advice here is get them to book in for us for some really specific legal advice.
Yeah, we'd be really happy to speak with them about that. That's not in our case study.
Yeah.
But we would be very happy to explore that one.
Okay.
And it's not unusual for example, well-meaning Mud Army members to throw out property that could otherwise have been saved.
Yep.
And that's another unfortunate thing that can happen in this space as well.
Yep.
And nobody there's done anything wrong, but it has a bad effect bad impact on the people involved.
Yeah, and that also raises some considerations for being trauma-informed when you're assisting clients with this. I had a client after I think it was a bushfire. Anyway, the house was completely destroyed and it had asbestos in it. And I know that in Central and Far North Queensland, we still have homes with asbestos in them. And before they were allowed to return to the property to try to retrieve significant jewellery items, there was a large amount of PVC glue poured over the property to settle the asbestos down. And so there is significant emotional distress that can come out of some of these situations for clients that make this work even more rewarding, even more important, but that much more important to deal with in a trauma-informed way for the clients and to take care of your own risk of taking on vicarious trauma.
And I guess the other good point that you raised that's part of that is communication is key from everybody involved in this. And it's not writing 3-page letters, and it's not writing the ER saying your claim is refused or accepted.
No.
It
needs to be meaningful.
It's having a meaningful conversation. I will often start by asking if I know the client has kids, how are the kids? Because school's just gone back, school's been interrupted, particularly in North Queensland at the moment, and how parents who thought after 8 weeks of summer holidays they were sending their kids back to school.
Yeah, I think that human element is really important in George's case. In Wednesday's case, we've picked 2 clients who have kids, but that's the case for a lot of our clients who can afford mortgages and homes. But that's a webinar for a different day. That they have children, but not only is it a house that's been damaged, it's the home that they live in with their children.
Yep.
And the damage that can be caused by bushfires or by floods can be quite brutally violent, and it leaves damage that can be a personal affront to someone. That's their daughter's room that now has black mold and a pungent odor.
Yeah.
And it adds that extra element to it for the clients, and it makes our support and the support of financial counsellors and consumer advocates even more important for the client in that space.
Absolutely.
The only other question we've come through relates to the previous case study about George, specifically his car.
Yep.
So this is the car that was already damaged at mechanics, has been further damaged.
Yep.
The audience member has asked, what if there was a loan on that car?
I was waiting for that question actually. The short answer is they've got an obligation to continue paying.
Yes, but we would advise him to seek a hardship variation, to at least pause the repayments. And I think that's what we could do in that.
What we hope is a successful insurance or court claim to cover that money. Remembering though that people insure their cars for an agreed amount often. So they say, if my car is written off, you'll pay me $8,000.
Yeah.
Sometimes there will be $10,000 owing on the loan.
Yeah.
And that insurance payout will not fully pay it out.
No. And if your clients have gap insurance or consumer credit insurance that they've bought within the last 4 years, just give us a call.
Yeah.
We'll deal with that separately.
I think that's a fair call. The other thing that could come into this space that we're not talking about is there could be body corporate fees, or there could be council rates accruing on this property while we're still waiting for it to be fixed.
Yes. Now, being from the country where there's low density, I don't know that much about body corporate, but I know about local council. And if you're not paying your rates, and your rates are, it depends from council to council, but what I've seen, 5 years overdue, they will sell your house. So it's really important that we can provide the client advice about seeking an extension of time to pay the rate.
And councils will often have programs in place following disasters, and it's important people ask those questions.
That's right.
Because if you don't ask, you don't know.
That's right. All right.
The other thing I noticed we haven't talked about that's probably worth having a chat about in the context of cash settlements is contingencies.
Yes. So I don't know if you mean that time that I was cheeky and asked for a cash settlement of the full claim now, but also we would come back and ask for more money as we needed it as time went on?
Well, there's a couple of things to talk about. The first being, if you're accepting a cash settlement, there should be a percentage added on to it to take account of the fact that insurers can get stuff done more cheaply than you or I can when we ask builders.
Yeah.
That would be the first thing. And there's lots of AFCA decisions confirming that.
Yes.
The second thing is the issue of, in theory, if you accept a cash settlement, in theory, that's the end of the claim.
I like the use of "in theory." Tell me more about that.
Well, for example, in the code, if you accept a cash settlement within 1 month of a disaster happening, you've got 12 months to go back to the insurer and say, I've found more damage. Can we relook at the cash settlement?
Or I remember how many bedrooms I have.
Yeah, exactly.
Yeah.
And I am aware that the code is being reviewed at the moment, and that time period is looking to be extended.
Which is great, because 1 month is hardly any time at all, particularly what we've seen in Townsville now. They've had weeks of rain coming down and rain coming up and rain coming down and water coming up. And a month isn't going to be long enough in those circumstances.
Yes, a shout out to Townsville, who I believe is seeing the sun for the first time in 16 days today. But the other thing about that is, sometimes it's not until you knock on the wall down and take the plasterboard off that you see other damage.
That's right.
Now, in theory, an insurer might be entitled to say, no, we're not looking at that further. But my experience is, when you raise it, insurers are always going to look at that extra stuff.
Yeah. Because
they're aware as well that sometimes you just don't pick it up until you start doing the work.
Yeah. And I think it's fair to say that Paul and I really enjoy insurance policies like no one else I've ever met. But we're also really interested right now in this sort of issue where you have a cash settlement, but it actually does cost you more, or you find more later. So just a shout out, if you have somebody in that situation, you're in that situation yourself, please call us for a chat. We really do enjoy it, and we would like to explore a bit further the limits of the law and good industry practice and the code's obligations for when an insurer can be required to come back and pay more.
Because it's something that us and insurers actually share the same interest in, because it improves the outcomes for consumers.
It does. And we can say that in our experience overall, that is actually what motivates insurers and ourselves, and we do have that in common.
Yeah. Do humans screw it up when they're dealing with claims? Absolutely.
This is true.
And look, if anybody out there is perfect and never made a mistake, let me know, because I'm certainly not in that category. But the thing is, when you pick them up, that's when you need to talk to the insurer and just say, can you have another look at this? I think somebody's had a bad day here.
Yeah.
And I have used those exact words with insurers before.
Yeah. Now, it can be just one person in an insurance company having one bad day, or it might be the case that the internal processes or the policies or the training is not right. Now, the only good thing that I have seen coming out of disaster events is that it gives us an opportunity as consumer lawyers to see a whole lot of people with the same issues in a short amount of time, and we're able to resolve systemic issues with insurers really quickly.
Yep.
So that's what we got going for us in disasters.
And it's led to change, which has helped people in major disasters.
That's right.
And so if you're ever in a position where you're thinking, why would I complain about this, or why would I tell legal aid or community legal centre about this, that's how we use it.
That's right. And for the was it 17% of people who were anyway,
Queensland?
yeah, this is our strength in sharing and collaborating with each other what our clients' experiences are. So there is very much strength in numbers, and we can get really good things done when we know about more examples.
Absolutely.
Do we have, sorry, Paul?
You're probably going to ask for questions.
Do we have any questions? I was going to
We
say, do we have time for our last case study?
I feel like you two were very much in tune with the audience, because we've had someone ask, can you give me some examples of taking cash settlements as a best option to settle an insurance dispute? Generally, we, lawyers, would never advise doing so.
So
start with your example.
I forgot my example.
The one with the builder next door.
No, you'll have to
okay.
Remind me a bit more, sorry.
So one example where a cash settlement was perfect for somebody was they had a builder next door, their dad was an engineer.
Oh yeah, that one, yeah.
That one, you with me now?
Yeah.
and somebody else on the street had expertise in rebuilding the property.
Yeah.
They had ready access to builders
Yeah.
and could quite easily rebuild the property in a short space of time.
Yeah.
The other example is what we were talking about before, where somebody's been flooded for the third time in 2 years.
Yeah.
And goes, I've had it.
Yeah.
Or it's not, I don't feel safe anymore. That's actually the phrase that's often used.
That's right. I've had enough. In my experience, it is, if there is a total loss, if it's up the amount of the sum insured plus all the additional benefits for removal of debris and temporary accommodation, if it is the maximum that you will get anyway, cash settlement is up to you.
Yeah.
And the things that I would caution against are, if you are rebuilding, you're going to have to sort this out yourself. But if you are moving on and the offer is for the maximum amount that you'll get, and it means that you can get that and move, that's when I'd say that's a good option. Where it's not a good option is for if you're not married to a tradesperson and you don't know how to arrange, how to project manage a rebuild of a home, or even just repairs for a home, and you're living in a suburb or a town or a region where thousands of people have been affected, so there's a shortage of material and a shortage of trades, I think that it can most likely lead to you only being able to afford to rebuild 60% of your home. And I have seen small towns in regional New South Wales and
same in Queensland
that are half rebuilt after disasters, and we don't want that.
None of us do. Next on the list.
Let's have a look. Sorry, I'm just catching up. What if you take cash, then another storm occurs? Are the insurer right to say that the house was not in a well-maintained state as there hadn't been time to fix it?
That depends on when you got the cash settlement.
No, I really want to know the answer to
Yeah,
this one.
I know that. I've given advice on similar situations actually. So, for example, if you got the cash settlement 2 weeks before the disaster happens,
yeah,
I think that's wouldn't be fair and reasonable for an insurer to say the property's not properly maintained. If you got the cash settlement 12 months ago and you hadn't started work at all,
yeah,
then we're probably in the realm of the insurer might be reasonable to say, hang on a minute,
yeah,
we've given you this money and nothing's happened.
Yeah, with the same disclaimers as before. If the damage is to the same area, then that's fair. But if in one case you had a damaged roof, in another case you've got a flooded bathroom, they're not related, and it's got nothing to do with it. But yeah, that is something.
It's a good question, and it's one I've seen, and we're probably,
so it's very fact based.
Yeah, absolutely.
Yeah,
absolutely.
They're coming through thick and fast.
Absolutely.
So
what's next?
Oh, sorry, I just wanted to. We won't have time for our last case study, but I did just want to mention one part of that case study because it's one of my favorite things that we were able to achieve as a systemic resolution as consumer advocates.
Contents inventory.
This is if you have lost everything in your home, and this started for us with the Queensland floods and the homes in Grantham that were literally washed away, and we had clients who were being asked to provide fully itemised and costed out lists of everything they owned. Now, I'm not at my house right now. I could not do one of those lists right now. Or if your house has been washed away, it's impossible, I would say. And so in the years since then, with some great consumer advocacy and some great collaboration on the insurance on the industry side as well, the General Insurance Code of Practice was amended and updated so that there is an obligation on insurers where there has been a total loss to approach those customers sensitively and not to require itemised lists of the loss. And I recently assisted a client in those exact circumstances, and I'm really pleased to see that the insurance company resolved it that day that I raised it with them, and that it seems to be one of the good developments we've had that is working.
Absolutely. Now, I notice we're really short of time, Catherine. Do we have another 5 minutes to answer
We absolutely
questions?
can have another 5 minutes, and I can see that most of our attendees are still online. Thank you everyone for hanging around. What we'll do is we'll go over by 5 minutes to get all your questions answered. If you have to leave, just know the webinar is being recorded. We'll be getting that recording added to our YouTube channel within the next week or so. So all the content that you may have missed will be on there. So we'll keep going with questions and then we'll do a really quick wrap up at the end.
Yep.
Are you happy for me to jump to the next question?
Go for it.
Please.
Okay, hi team. Often I see that the insurer has stated the maintenance clause and the client has gone and got engineering reports, builder reports, etc. to say that it wasn't a maintenance issue and still has the claim declined, e.g., home needed restumping 2 years ago. What's the best course a client can take within this type of environment?
Internal disputes, and then if need be, AFCA, the Australian Financial Complaints Authority.
And my suggestion would be don't muck around with the timing of it. Get it into the internal dispute resolution part of the insurance company, because that's a separate section from claims, and those the staff in that section are specifically for resolution of disputes, for looking at it. And in our experience with insurance, that it is actually a well-trained different part of the company than claims, and not always, or in our experience, it's not just rubber stamping what the claims department said, but then they have 30 days to resolve or to work on it and come back to you with a response. And if it's still not successful, go to AFCA. We are seeing, AFCA is seeing a whole lot more disputes, and that means that there is a longer time that you need to wait for it to be resolved with AFCA, and that's why I would suggest don't delay with getting it in there.
But the advantage is it's free. And will always be free to consumers.
Free for consumers, and it is my favourite jurisdiction because it looks not only at what the law says and what's in the contract, but it looks at what's good industry practice, including the General Insurance Code of Practice, even for non-members, and it looks at what is fair and reasonable in all the circumstances. Yep. And that is the difference there between AFCA and a court or a tribunal, that it can look beyond the legal and look at what's actually happened, and it is designed to be impartial and fair.
I agree.
Okay. Oh my goodness, another one. Just a second. What qualification does the company have to have for the insurer to accept? Sorry, I'm just not seeing where that's gone. For the insurer to accept their roof check report.
I'd be more interested in what grounds would an insurer have to not accept a report. I think maybe it's a QBCC license number.
Okay.
Yeah, for example, if my uncle, who's a school teacher, gets up on the roof, probably it doesn't fall off, probably not accepting his expert report.
But not to completely discount, that's still evidence of what your uncle saw your roof to be.
Absolutely.
It can still be used, as can photos of a family barbecue show that the window was not broken at that time.
Yeah, but it would go to the weight you would put on an expert report.
He's not an expert there, but an expert would be a qualified trade, a skilled trade, and it depends on, again, the facts and the circumstances.
Absolutely.
How recent does that roof report have to have had occurred? Is the follow-up to that?
Yeah, that's a really good question. And that's the thing, that's the issue Paul raised before. What is maintenance, and what am I supposed to do with my house, and how often am I supposed to do it? Because I've only just learned that I'm supposed to get termite inspections every 6 months. So that's on the list. But what else as a homeowner am I supposed to do?
And how often do you need to do it? And I think this is an important discussion we're going to have with insurers.
Yeah.
Around what that looks like.
I think that's
because I don't think that's actually set down anywhere.
Yeah, that's a real opportunity for insurers to assist their customers to meet that.
Okay, we've got enough. This is a long one, so tune in. Okay, this is about the Disaster Recovery Structural Assistance Grant, SAG recipient.
Yep.
So 10 months after government QBuild scope of works issued there has now been additional damage occurred due to length of time waiting for builder.
Yep.
Is there any right to ask Gov to reassess damage, e.g. hot water solar system that sat on roof for 12 months, now full of dirty flood water, now rusted? Sorry, I'm just scrolling here.
Yeah. Is that Queensland?
Yeah, that's Queensland. That's Queensland.
And it's leaked through onto the repaired roof into the building still being repaired.
Two things. I would talk to the government and I would get legal advice about the specific circumstances.
Yeah. I think that does raise a really good question about the amount of time between when the disaster happened and when the repairs happened, and not just for QBuild or the grant, which, sorry, I don't know about that Queensland government part, but by the insurers as well, in circumstances where there's a trades shortage. and whether that delay caused more damage that could have been avoided. I'm really interested in how insurers will approach that and how AFCA will approach that. That's a live issue for us now with some
and
people in far off Queensland.
My experience is insurers accept that damage should be covered.
Excellent.
Now, are we at
That's
the point
it
of
for
a wrap-up?
questions. I think we are. So if you have any more questions, feel free to email the webinars at Legal Aid email address, and we will forward them on to Paul and your team, and
Absolutely.
we'll get those responded to for you. I'm just going to do a really quick wrap up, everybody, and let you know what our next webinar topic is going to be next month. Just to flag here the phone line for people to call if they do need legal advice. It's the 1300 527 700 phone number.
And that's a priority line that gets answered.
That will get to us quicker than any other number.
Yeah.
Okay, perfect. Because we do have a few different phone lines at Legal Aid. So that's the specific one for disaster legal help. We also have our general 1300 65 1188 number. That's for people needing legal information and referrals. We also have a priority phone line for First Nations people. So that's the 1300 65 0143. That will be answered as a priority in our call queue. If you've got a client that's already submitted an application for a grant and you have a follow-up question about it, that last phone number there, 1300 383 900 is the number to call. So these webinars are part of our community legal education program here at Legal Aid. Another resource we have are lots of free publications, brochures, fact sheets, all sorts of things on our website. They're all free. They're a fantastic resource for you. So please go on the website, look for publications. You can download them, you can print them, you can order them for free, and they'll be delivered to you for free as well. So please do go and have a look at that free resource. Our webinar next month in March will also be featuring Paul as a speaker, and it's going to be looking at cost of living pressures and protecting people's rights. So I hope you can join us for that one as well. We'll be starting to promote that one from tomorrow. That's on the 19th of March, so look out for that one. As I mentioned earlier, we do record and caption all of our webinar recordings, and we publish those on the Legal Aid Queensland YouTube channel. And anyone who's registered for this webinar will be sent a link to that recording. And please follow us on our social media to hear about upcoming webinars and other CLE resources that we develop. That's it for us today. I want to thank everyone for staying on the line. We really appreciate you being here, and I hope this content's been really helpful for you and your clients. Paul and Julie, thank you so much for joining us. It's been fantastic, and we'll see you at the next one.
Thank you very much.
Thanks, everyone.
Thank you.
See you, everyone.